Hello there, everybody. Thank you for joining me once again today. My name is David Bryson, and we will be focusing on the fourth installment of our series on sui juris, presenting yourself in court. Today, we will be focusing on preparing for trial. So before we jump into it, let me go ahead and pull up a screenshot here. Our awesome cover art for our Facebook page, Sui Juris Law for Beginners. And we encourage everybody to embark on the study of law. It's a wonderful journey, and connecting with the right materials and the right people, you will see how it's thrilling and inspiring to know your rights, to know how expansive a space in which to move and express yourself, your rights guarantee you, and to protect yourself from being hoodwinked by the state or by anybody else who would take advantage of your perceived ignorance of the law. So we're all about empowering people by giving them an understanding of the law. The law is our advocate. It's there to protect us, and we just have to make people perform what the law demands, whether they're judges or lawyers or whoever. No one is above the law, and that's what all of our studies of law are kind of based upon, that premise. So, jumping in today, we're going to be focusing on pretrial procedures, getting ready for trial. We're going to focus on understanding and following pretrial deadlines, pretrial conferences. We're going to discuss court order mediation and arbitration. We're going to discuss initial pretrial procedures and setting the ground rules, how to file a proof of service, and an Issue Memorandum. We're going to discuss the matter of attending an early meeting of parties and preparing a report. We're going to get into the matter of attending a scheduling conference and how to make a demand for a jury trial. We will discuss the intermediate pretrial procedures of discovery and motions. And then the final pretrial procedures, trial preparation is involving preparing a joint pretrial memorandum, handling other pretrial documents, attending a final pretrial conference, and obtaining a pretrial order, and attending a mandatory settlement conference. So turn up the volume, kick back and enjoy yourself, get out your pencil and paper, take some notes if you'd like. And let's jump right into our awesome subject for today. This video provides an overview of the procedures that commonly take place between the conclusion of an initial paperwork stage of a lawsuit, see video number 3, and the time that a case either settles or goes to trial. Despite what we have seen in movies and TV shows, most cases don't go straight from initial papers to trial. Like most civil litigation professionals, like lawyers and paralegals, you will probably spend most of the time you devote to your case not in court, but instead engaged in the pre-trial activities outlined in this chapter and described in more detail throughout the rest of this video series. Pre-trial tasks include preparing and gathering documents, exchanging them with your adversary, and participating in the process of fact investigation called discovery. And at least the first few times you go to the courthouse, it likely will not be to conduct your trial, but to participate in a pre-trial conference with your opponent, and often a judge, or to ask the judge to decide some preliminary dispute called arguing a pretrial motion. Especially if you represent yourself and are unfamiliar with litigation, it is important to understand at the outset that the pretrial stage of your case is likely to be time-consuming. Rules governing pretrial activities tend to be technical and exacting. This is the inside stuff of the law, generally familiar only to experienced attorneys and paralegals, and often changed by legislators and judges in response to attorneys' maneuverings. Moreover, While some processes will be dictated by state law and followed in all of a particular state's courthouses, others may be a product of local court rules and even unwritten customs that operate only in the courthouses of a single county. Thus, while we can outline common pretrial procedures, we can't anticipate all of the local rules and practices that may follow in your case. Your court may follow a practice not touched on below, may refer to a similar procedure by a different name, or may follow similar procedures but in a different order. Also, if your case involves less than $50,000 and doesn't present complex legal issues, it may be put on an expedited, quote, short cause, unquote, calendar. In these cases, many of the processes described in this chapter don't apply or are streamlined. To find out which procedures will apply to your specific case, you'll have to consult your state and local rules carefully and talk to your legal coach if you have one. Courthouses often provide procedural rules, and the latest versions of court rules are generally available in public libraries and online. For more information about how to do legal research, including websites where you'll find court rules and legal forms, see video number 23. Know and follow pretrial deadlines. The substantial roster of pretrial procedures outlined in this chapter typically unfolds according to a fast-paced schedule that is, at least in theory, subject to rigorous oversight by judges. In many areas of the country, the swift pace of pretrial activities, often called fast track or rocket docket procedures, has reduced the long case backlogs that were common just a few years ago when parties themselves had the power to dictate the pace of litigation, subject only to very loose statutory controls. If you're serious about representing yourself in court, be prepared to meet a number of pretrial deadlines for filing documents in court, exchanging documents with your adversary, conducting discovery, and attending conferences with your opponent and possibly the judge. Caution: pro se litigants must follow the rules. Most judges won't cut you any slack simply because you're representing yourself and doing your best to negotiate a minefield of unfamiliar procedures. Miss a deadline, and you may have to pay a penalty to your opponent or lose a right that you might otherwise have had. For example, to ask for a jury trial or to take a particular witness's deposition. Miss deadlines frequently, and the judge may even dismiss your complaint or answer. Pretrial conferences. If your trial goes all the way to trial, if your case goes all the way to trial, or even if it settles the day before, you probably will participate in a number of meetings along the way, often with both your adversary and a judge present. These pretrial conferences go by different names in different courts, sometimes depending on when in the pretrial process a conference takes place. For example, a pretrial conference might be called a scheduling conference, an arbitration status conference, a status conference, or trial setting conference, or a settlement conference. And while a particular state's court rules may require only attorneys, not parties, to attend some types of pretrial conferences, if you're self-represented, you will have to attend all of them. Court rules require conferences in nearly every civil case. Federal Rule of Civil Procedure 16A and similar rules in most states grant judges discretion to order attorneys and self-represented parties to attend additional pretrial conferences to discuss such matters as settlement and discovery, or to whittle down the number of disputed issues in the case. For a more complete list of subjects that are commonly discussed during pretrial conferences, see Federal Rules of Civil Procedure 16C. Court-ordered mediation and arbitration. In addition to slogging through a succession of pretrial activities, in many states, a judge may order you to attempt to settle your case through mediation or arbitration, sometimes both. Broad rules designed to promote settlement authorize judges to sidetrack certain types of cases, for example, child custody cases and cases involving less than $50,000, by ordering the parties to take their disputes through some form of alternative dispute resolution, or ADR. Usually this means mediation or arbitration. In mediation, a neutral third party, the mediator, gets the parties together and tries to facilitate resolution of a dispute in an informal setting. The mediator has no power to impose a settlement. If the mediation fails, the case typically comes back on track and proceeds to trial or settlement as though the mediation had not occurred. Arbitration is more formal than mediation. It resembles a trial in that, like a judge, a neutral third party, the arbitrator, hears testimony, examines documents, and issues a decision, usually called an award. In some cases, an arbitrator's decision has the same finality as if it were issued by a judge or jury. But in others, especially if you didn't agree in advance to be bound by the arbitrator's decision, you have the right to reject it, which means your case will be returned to the court system. However, if you reject an arbitration award that turned out to be more favorable to you than the outcome of trial, you may be ordered to pay your adversary's court costs. For more information about court-ordered mediation and arbitration and tips for representing yourself effectively in both types of proceedings, see video number 6. Initial pretrial procedures. Setting ground rules. This section examines pretrial activities that commonly take place shortly after the initial pleading or paperwork stage is complete. These early procedures can be critical because decisions made at this time often determine the scope and timing of the pretrial activities to follow. Filing a proof of service and an Issue Memorandum. In most states, the service of a complaint and answer is not sufficient to start your lawsuit rolling towards settlement or trial. If you are a plaintiff, you also have to start the clock by filing a paper called a proof of service that notifies the court that your complaint has been served on the defendant. Federal Rules of Civil Procedure 4L, see video 3. In addition, you may need to file a separate document, sometimes called an Issue Memorandum, that indicates that the defendant has filed an answer. If you want a jury trial, but didn't make a jury trial request in your complaint or answer, you may do so in the memorandum. Alternatively, court rules may require that you make a jury request in a separate document. Attending an early meeting of parties and preparing a report. Federal Rules of Civil Procedure 26F and similar rules in many states require you to meet with your adversary as soon as practicable after a complaint and answer have been filed. This meeting typically must take place before the judge conducts what is often called a scheduling conference and issues a scheduling order. You and your adversary generally have to arrange the meeting yourselves. You might not get a notice from the court ordering you to meet. The issues that you and your opponent are expected to discuss in good faith during this meeting include the following: your competing claims with an eye to a possible quick settlement, the timing of the disclosures that you and your adversary must provide to each other under Federal Rules of Civil Procedure 26A3. Federal and many state courts provide that very soon after the early meeting of parties, the parties must exchange basic information such as the names, addresses, and telephone numbers of potential witnesses and the identity and whereabouts of relevant documents. For more information on what has to be disclosed under Federal Rules of Civil Procedure 26A3, see video 5. The formation of a discovery plan, which often includes the issues on which each party will seek discovery and the timing of each party's depositions and other discovery requests. For a description and analysis of discovery methods, see video 5. And finally, the final issue that you're expected to discuss in good faith during these meetings is an estimate of how long the trial will take. Under Federal Rules of Civil Procedure 26F and similar rules in many states, you and your adversary are required to prepare a single joint report of early meeting or some similarly named document that outlines the meeting reached during, that outlines the agreements reached during your early meeting. You must submit the report to the court within 10 days after the meeting. If you are representing yourself and your adversary is represented by an attorney, the attorney may offer to prepare and submit the report. If so, make sure that the attorney sends you a draft before submitting the report to the judge so that you can carefully check to see that it reflects the agreements you made. A sample joint report will be included shortly. Caution. Beware of slanted reports. Whoever drafts any court document has many subtle and sometimes not so subtle opportunities to slant it in the drafter's direction. Always read drafts of reports and other documents prepared by your adversary promptly and carefully. If they don't reflect what you agreed to, rewrite the misstatements and mail, fax, or email the document back to your adversary. You may have to exchange several drafts before you reach consensus. With a document such as a joint report of early meeting, bring your final draft to the conference with the judge in case it differs from the version your adversary presents. Sometimes you'll agree to include each party's version of some elements of the report. Attending a scheduling conference. The scheduling conference described in Federal Rules of Civil Procedure 16b is likely to be the first pretrial conference you'll attend with the judge. A scheduling conference may often take place in the judge's office, often called chambers, with you, your adversary, and the judge all present in person. However, the conference may also take place via telephone or by electronic means. Rule 16b puts the judge in a role of case manager. Normally, after reviewing the early meeting report discussed above, and hearing from both parties at the scheduling conference, the judge will issue an order, often called a scheduling order, that sets time limits for filing any pretrial motions, completing discovery, conducting other pretrial conferences, and starting trial. As a self-represented party, you may find it difficult to predict how much discovery you'll need to do and how long it will take. One option is to consult a legal coach before attending the scheduling conference. Also, ask the judge to give you leeway when settling deadlines. For example, a portion of your scheduling conference may go as follows. Judge speaking. It seems to me that all depositions can be finished by March 31st. You. Your Honor, I'll do my best to do that, but I need the medical records from Mercy Hospital before I take my opponent's deposition. And to do that, I'll need to serve the hospital with a subpoena duces tecum, duces tecum, D-U-C-E-S-T-E-C-U-M. Not only that, the supervisor of records at Mercy told me they are temporarily short of staff, so they may be delayed in sending out the records. In view of all this, I'd ask that I have until the end of April to depose my opponent. I don't think that the extra month will affect the trial date that you've given us. Judge responds, well, you've done your homework and I know what you have to do, so I'll grant the request and give both parties until the end of April to complete all depositions. In the example above, a judge will probably be more inclined to grant your request for more time if you indicate the reasons why you need it and demonstrate familiarity with pretrial procedures. You must have a good reason to obtain a flexible scheduling order. Under Rule 16b, a judge will consider your request for a change in the order only if you can demonstrate, quote, good cause, unquote, for needing more time. Though the judge formally makes the scheduling order, you and your adversary will likely be expected to prepare a proposed order for the judge's signature. You won't have to go very far in the pretrial process before you realize that most orders issued by judges are in fact prepared by one of the parties for the judge's signature. The proposed order may simply be tacked on to the end of the joint report of early meeting. A proposed order may resemble the sample soon to follow. Making a demand for jury trial. If you want your case tried by a jury rather than a judge, you'll probably have to submit a written demand for a jury trial, along with payment of jury fees, long before trial takes place. For example, Federal Rules of Civil Procedure 38 requires jury trial demands to be served and filed no later than 14 days after the last pleading directed to the issue is served. Typically, that is the defendant's answer. For further discussion of jury demands and the jury selection process, see video number 10. Now, in some courts, you may make a jury trial request in the complaint or answer or in the at-issue memorandum discussed earlier. Intermediate pretrial procedures, discovery, and motions. Once the ground rules are laid out, most cases move into an intermediate phase in which the main activities center on the methods of fact investigation, which is otherwise known as discovery. Let me repeat that. Once the ground rules are laid out, most cases move into an intermediate phase in which the main activities center on the methods of fact investigation or discovery that are discussed in video number 5. Parties are supposed to carry out discovery on their own without active participation by the judge. However, if a dispute arises or if you or your adversary want the judge to make legal rulings as to the scope or the merits of the case, you may also make or respond to motions, written requests for court rulings on legal issues. So again, I'm going to repeat that. If a dispute arises, or if you or your adversary want the judge to make legal rulings as to the scope or the merits of the case, you may also make or respond to motions, which are written requests for court rulings on legal issues. Discovery. Most civil litigators spend the bulk of their professional lives engaged in the process of fact investigation. When you represent yourself, you too will participate in the fact investigation process with an eye toward accomplishing 2 primary goals: developing credible evidence that supports your own legal claims and uncovering and trying to undermine the supporting evidence your adversary is likely to put forward. As discussed in video 5, some fact investigation may be informal. For example, you might interview a witness privately or ask a government agency to send you a report that pertains to your case. But informal investigation may not yield all the information you need to achieve the 2 goals mentioned above, which are developing credible evidence that supports your own legal claims and uncovering and trying to undermine the supporting evidence your adversary is likely to put forward. For one thing, you can't make anyone turn over information unless you use a formal discovery method. And information you do get through informal investigation may not be in a form that is admissible at trial. Formal discovery methods, by contrast, allow you to compel disclosure, that is, force the sharing of information, of many types of relevant information from adversaries, private companies, government agencies, and witnesses who aren't parties to the case. Moreover, as the information you'll get by using a formal discovery method is provided under oath on the record and subject to discovery rules, it is more likely to be admissible as evidence in trial. As set out in video 5, The discovery processes you are most likely to encounter are depositions, written interrogatories, requests for production of documents, and requests for admissions. Each of these discovery methods resembles the children's card game of Go Fish. That is, you may be legally entitled to the information you seek, but only if you ask for it properly. To curtail the more obnoxious gimmicks that attorneys may use to hide information during discovery, many jurisdictions have enacted rules requiring initial disclosures. Initial disclosure rules require parties to voluntarily, without waiting for the adversary to ask, reveal such information as the names, addresses, and telephone numbers of potential witnesses, documents containing information pertinent to the case, and the basis of demands for damages. Information subject to initial disclosure is often set forth in the joint report of early meeting. For more information on initial disclosure and discovery tools, including evaluation of the comparative advantages and disadvantages of the different methods of fact investigation, see video 5. Motions. A motion is a formal request asking the judge to rule on a legal or procedural issue. While judges' rulings on some type of motions concern pretrial procedures, rulings on other types of motions can determine which party wins and which party loses. To file a motion, a party must prepare the appropriate moving papers, serve them on an adversary by mail, file them in the court in which the case is pending, and appear personally before a judge to argue why the judge should grant the moving party's request. The moving party, that is the one who is making the motion, which again is a formal request asking the judge to rule on a legal or procedural issue. The moving party may also have to try to resolve the dispute informally with the opposing party before asking the court to step in. Video 7 explains motion procedures in more detail. Motions usually relate to issues that arise during the pretrial phase of litigation. Some common pretrial motions are motion for continuance. This motion usually asks a judge to postpone the date of a court hearing or to extend a deadline for filing a pleading or providing an adversary with information. You'll only file a motion like this if you've already asked your adversary to agree to the postponement without success. A motion to dismiss. This motion is normally filed by a defendant to obtain a ruling that a plaintiff's complaint fails to state a valid legal claim and therefore should be dismissed, thrown out of court either in whole or in part. Motion to compel answers. This motion is made in connection with discovery procedures, usually to seek a ruling that an adversary has to turn over information that it has improperly refused to provide. Motion for sanctions. This motion asks a judge to punish a party for ignoring previous court orders, failing to comply with court rules, for example, for conducting discovery in such a way as to cause annoyance, embarrassment, oppression, or undue burden or expense. And motion for summary judgment. In this very crucial motion, the moving party asks the judge to decide the entire lawsuit in its favor without ever having a trial. To win a summary judgment motion, the moving party must show, in essence, that a jury could not possibly decide the case in favor of the other party. Judges decide summary judgment motions by reading written affidavits rather than by listening to witnesses. So preparing the paperwork that supports or opposes these motions is a very painstaking task. For more information about summary judgment motions, see video 7. Though most motions are made before trial begins, parties can also make motions as part of the trial process itself. For example, a motion in limine is made at the beginning of a trial and asks a judge to decide whether certain evidence will be allowed, admissible, during the trial. Motions may also concern issues that arise after a trial. For example, a motion for judgment notwithstanding the verdict, or JNOV, JNOV, asks a judge to overturn a jury's unfavorable decision. See video 20 for more on the jury for the judgment on. See video 20 for more on a judgment notwithstanding the verdict motion. For further discussion of motions, example of common motions, and suggestions about how to handle yourself during a court hearing on a motion, see video number 7. Final pretrial procedures. Trial preparation. During the 30 to 60 days before your case is supposed to go to trial, the judge may schedule additional pretrial conferences so that you and your adversary can continue to explore settlement. Judges know from experience that many cases do settle in the shadow of the courtroom. For further discussion of settlement strategies at a pretrial conference, see video 6. Although the judge hopes your case will settle, the judge will also expect you and your opponent to cooperatively develop a plan for the trial that will ensure it is conducted in an orderly and efficient manner. As a result, you'll probably have to identify in advance such matters as the legal theories you'll present, the witnesses you plan to call, and the evidence you plan to introduce at trial. Preparing a joint pretrial memorandum. You and your adversary should prepare a joint pretrial memorandum or some similarly named document and submit it to the judge before the final pretrial conference. The subsections below identify information commonly included in such a pretrial memorandum. Pretrial disclosures. Federal Rules of Civil Procedure 26A, subsection 3, and similar state rules require parties to make pretrial disclosures that provide information about the evidence each plans to offer at trial. Under Federal Rules of Civil Procedure 26A3, you and your adversary must serve each other with these disclosures at least 30 days before trial. The information you are required to disclose in writing under FRCP, Federal Rules of Civil Procedure 26A3, includes the names, addresses, and telephone numbers of each key witness you expect to call, including expert witnesses and yourself, if you will testify. If you plan to use an expert witness at trial, FRCP 26A2 also requires you to provide your adversary with a report describing the expert's testimony. This report is due at least 90 days before the trial date. Next, information that you are required to disclose in writing before trial are the names, addresses, and telephone numbers of each witness you may call if the need arises. These are secondary witnesses, people you plan to call only if you are in an unexpectedly tight spot. For example, you may not know whether one of your primary witnesses will be able to come to the trial or will be able to remember enough details to be a credible witness. In either event, if you have a backup witness, you should list that person as a witness you may call if you need to. And then finally, you will be required to disclose in writing evidence you plan to offer in the form of deposition testimony. If a witness whose deposition has been taken is unavailable to testify in person at trial, you might be able to introduce the deposition testimony that you consider helpful at trial. Federal Rules of Civil Procedure 26A3 requires you to disclose in advance your intention to offer deposition testimony instead of a witness. If the deposition was videotaped rather than recorded in a deposition booklet, you must also include a transcript of the deposition testimony you plan to offer. Caution: familiarize yourself with deposition rules. If you plan to offer deposition testimony as evidence at trial, or if your adversary intends to do so, read Federal Rules of Civil Procedure 32A4. This section explains when a witness is legally considered unavailable to testify, meaning that you can introduce the witness's deposition testimony at trial instead, and describes how to offer deposition testimony into evidence. Also, be aware that the rules of evidence at depositions are much broader and less strict than they are at trial. So testimony that was allowed at a deposition will not necessarily be admissible at trial. If you or your adversary intends to offer important evidence from a deposition, you should probably consult a legal coach or resource such as NOLO's Deposition Handbook by Paul Bergman and Albert Moore. Video 5 also provides information about depositions. Identifying information about any document or other exhibits you expect to offer or may offer if the need arises, including a summary of its contents. That would be the final bit of information, jumping back to before, the information that you're required to disclose in writing as far as pretrial disclosures, would be identifying information about any document or other exhibit you expect to offer or may offer if the need arises, including a summary of its contents. After the parties have served each other with pretrial reports, pretrial disclosures containing the information described above, and filed these reports with the court, Federal Rules of Civil Procedure 26A3 gives you and your adversary 14 days to object to the admissibility of deposition testimony or to any documents or exhibits that the opposing party identifies in the reports. If you don't make an objection before trial, you waive your right to do so unless the trial judge concludes that you had, quote, good cause, unquote, for failing to object earlier. Though these provisions may help trials proceed more quickly, they mean that you can't wait until trial to decide whether deposition testimony or a document that your adversary plans to offer at trial is admissible. You have just 14 days after getting the pretrial disclosures to object. And if you don't object, you probably won't be able to do so at trial. Jurisdictional statement. Under the U.S. Constitution, federal courts have power to decide only certain types of cases. See video 3 for discussion of federal jurisdiction. In legal lingo, they are called courts of limited jurisdiction. Therefore, a plaintiff must be ready to establish that a federal court has jurisdiction over a case, and the joint pretrial memorandum in a federal court case should clearly state the basis of the court's power. For example, the jurisdictional statement in a pretrial memorandum might indicate that this court has jurisdiction because the parties are residents of different states and the amount in dispute exceeds $75,000. Most state trial courts are courts of general jurisdiction, so you usually won't need to include the basis of state court jurisdiction in a pretrial memorandum for state courts. Legal contentions. Complaints and answers often set forth many possible legal theories. By the time trial is near, discovery has often clarified many facts and reality has begun to set in. As a result, each party often decides to rely on one or at least a very limited number of key legal theories and let the rest go. The theories that the parties will try to prove at trial should be identified in the joint pretrial memorandum. For example, assume that you're a plaintiff in a personal injury case and your complaint alleges that the defendant is liable for injuries you suffered both because the defendant was negligent, unreasonably careless, perhaps driving too fast, and because the defendant's conduct was in violation of the legal code, like ran a red light. Though you include both of these theories in the complaint, make sure that you also set them out in the pretrial memorandum and in the judge's pretrial order. Legal theories can be relied on at trial only if they are part of such an order. On the other hand, assume that your complaint in the same case asks for damages for the personal injuries you suffered in an auto accident and for the earnings you lost for the time you were off work recovering from the injuries. By the time of trial, the defendant has compensated you for the lost wages, and the only remaining dispute is the extent of your injuries. In this situation, you could drop the claim for lost wages by not mentioning that claim in the pretrial memorandum or order. Factual contentions. To set limits on the scope of the evidence that will be presented at trial, the judge may require you and your adversary to identify your factual contentions. For example, you might provide a summary narrative of events that you claim constitute a basis for relief if you are a plaintiff, or legal defense if you are a defendant. The joint pretrial memorandum should identify any facts on which you and your adversary agree. These are called undisputed facts. The judge's pretrial order will probably state that the parties have stipulated, which is they've agreed in writing, that these facts are accurate, and in a jury trial, the judge will simply read those facts to the jury to save time. The adversarial feeling of litigation may make you reluctant to agree to your adversary's request to admit that certain facts are true. However, admissions are a good idea if you don't genuinely dispute a fact's accuracy, or if the fact is obviously not important. As a practical matter, a shorter, simpler trial is in your interests. And if you refuse to agree, your adversary can serve you with a set of requests for admission. See video 5. If you continue to refuse to admit to the accuracy of facts that are later proved to be true at trial, the judge will almost certainly order you to pay your adversary the cost of proving those facts at trial. Handling other pretrial documents. In addition to the joint pretrial memorandum, you may be required to prepare or respond to a variety of other trial-related documents. The subsections below briefly describe these additional documents. Jury instructions. In jury trials, jurors are given information about the law that relates to the facts of the case. This information is presented to jurors in the form of jury instructions. Traditionally, judges read the jury instructions to the jurors, sometimes at the outset of a trial and sometimes at a trial's conclusion. Prior to the final pretrial conference, the judge may ask you and your adversary to serve each other with proposed jury instructions and to make any objections you have to the other's proposed instructions. For a list of resources that provide pattern or model jury instructions for use in common types of trials, see video 23. Voir dire questions. Voir dire questions, that's V-O-I-R-D-I-R-E. Voir dire questions. Voir dire questioning probes potential jurors' experiences and beliefs to determine their fitness to serve as jurors in your case. In most courts, jurors do all or part of the voir dire questioning. Parties can often submit with the joint pretrial memorandum any questions that they want the judges to ask prospective jurors. For further information on voir dire questioning, see video number 10. Trial briefs. Briefs are written arguments whose length often belies the name. Before trial, parties may submit briefs to try to convince the judge to make a ruling in their favor. For example, a trial brief may argue that an important item of evidence is or is not admissible, in which case, especially if a jury is involved, it may also be called a motion in limine, or that a particular legal principle is or is not applicable. If you are an inexperienced party representing yourself, you may find it difficult to prepare a trial brief or respond to one filed by your adversary's lawyer. Before you can prepare a trial brief arguing the admissibility of evidence or the validity of a new legal principle, you'll probably need to do legal research or consult with a legal coach. Motions in limine, L-I-M-I-N-E. The typical purpose of a motion in limine, literally a motion made at the threshold of trial, is to seek a judge's ruling that evidence the moving party's adversary plans to offer at trial is inadmissible. I'll repeat that. The typical purpose of a motion in limine, literally, which means a motion made, quote, at the threshold, unquote, of trial, is to seek a judge's ruling that evidence that the moving party's adversary plans to offer at trial is inadmissible. For example, a defendant's motion in limine in an auto accident case might ask a judge to rule that evidence that the defendant was insured at the time of the mishap is irrelevant and unduly prejudicial, and therefore inadmissible. A motion in limine is an alternative to the more common and simpler strategy of objecting to evidence when it's offered into evidence during trial. Some of the advantages of such a motion are: 1, the motion is usually in writing, so it may carry more weight than an oral objection made during trial. 2, the motion will probably be accompanied by a memorandum of points and authorities, that is, laws, court rules, and case decisions that back up the party's legal position, which the judge will have more time to consider before trial than in the heat of trial. 3, if the judge denies or postpones rulings on the motion, the party can and should renew the objection when the evidence is offered during trial. In that event, arguments made at the time of the hearing on the motion in limine may add to the force of the objection at trial, where time is short. 4th, the motion is made and considered. Again, these are some of the advantages of the motion of limine. Fourthly, the motion is made and considered before the jury is seated, so the jurors can't be influenced by any statements made by the judge or attorneys in connection with the motion. If your adversary submits a motion in limine, you will probably have a chance to oppose it both in writing and during an oral pretrial hearing. If you want to oppose the motion but are unfamiliar with evidence rules, you'll probably have to do some legal research and consult a legal coach. Video 16 may also provide helpful information. For more about motions in limine, including a sample, see video 17. Attending a final pretrial conference and obtaining a pretrial order. Federal Rules of Civil Procedure 16D and similar rules in many states provide for a final pretrial conference to be held as close to the start of trial as is reasonable. During a final pretrial conference, you can expect the judge to focus on a plan for trial. For example, the judge will probably want you and your adversary to agree on the legal issues that have to be decided at trial and agree to the non-disputed issues, the witnesses to be called, and the order in which they will be called. If you will have a jury trial and you or your adversary has filed a motion in limine, the judge may also rule in advance on the admissibility of some types of evidence. For example, the judge may rule that a police report that your adversary wants to submit as evidence at trial is hearsay and therefore inadmissible. See video 16 for more on hearsay. Many of the decisions arrived at during the final pretrial conference will be based on information in the joint pretrial memorandum. After the pretrial conference, the judge is likely to enter a pretrial order reflecting the agreements made in the joint pretrial memorandum and decisions made at the pretrial conference. See Federal Rules of Civil Procedure 16D. Most states have similar rules. The contents of the pretrial order are extremely important, more than any other document. The order serves as a roadmap for trial. The pretrial order supplants the initial pleadings and determines the legal theories that you and your adversary can rely on at trial. For instance, if you're a defendant and you've claimed or alleged in your answer that the plaintiff's claim was filed too late and is therefore barred by the statute of limitations, you can raise your statute of limitations issue in the courtroom only if the pretrial order identifies it. Consequently, you must make sure that any witness you want to call, any document or exhibit you want to introduce into evidence, and any legal theory you want to rely on at trial is included in the pretrial memorandum and order. Attending a mandatory settlement conference. Most state courts require parties to meet with the judge shortly before trial, specifically for the purpose of talking settlement. If a mandatory settlement conference is scheduled in your case, the judge might require you to specify the terms on which you are willing to settle your case. The judge who presides over your settlement conference may be a settlement specialist whose main task is to rather than try them. Judges who specialize in settlement are often the most experienced, capable, and persuasive judges in the courthouse. During a settlement conference, a judge may talk to you and your adversary, both lawyer and client, separately several times, trying to winnow down the areas of disagreement and promote what the judge considers a realistic assessment of the trial's outcome. Such a judge can be your best friend, saving you the time and rigors of a courtroom battle and persuading your adversary to settle on terms that are acceptable to you. Caution, just say yes. Whether you are a plaintiff seeking money or a defendant trying to avoid paying it, be grateful for a judge who can get you 2/3 or even half of the loaf from a contentious adversary. As you are almost surely inexperienced, it is almost always in your best interest to accept a reasonable settlement in order to avoid a trial. To put it bluntly, if a deal is even half good, you should say yes. Okay, that's where we're going to leave off today for pretrial procedures. And video 5 is going to be investigating your case. We're going to get into formal discovery, depositions, the advantages and disadvantages of taking depositions, how to take them, defending them, and deposition objections. We're going to discuss written interrogatories, their advantages and disadvantages of sending interrogatories and drafting interrogatories. And then finally, requests for production of documents and subpoenas, and requests for admissions. So, once again, we thank you for joining us in this series of Sue Juris, presenting yourself in court. My name is David Bryson. Thank you for subscribing to my YouTube channel, and we hope that you will share this information with other people and that we can become empowered people who know the law and know how to wield it in our favor and to our advantage. Be blessed, and thank you.